A tragic case out of Arizona. A 9-year-old boy is accused of fatally shooting his 5-year-old sister with an AR-style rifle. Police say their father left the weapon unsecured, and now he is under arrest. According to investigators, the father told officers he was outside his Phoenix home when he heard a gunshot. He reportedly rushed inside and found his young daughter gravely wounded. Now he's facing criminal charges in connection with the deadly shooting. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime. For this story, we go to Phoenix, Arizona, where a call for help came in just after 9 p.m. on June 3rd. According to KTVK, 33-year-old Irvin Ramos-Jimenez called 911. At first, he told the dispatcher his daughter had been stabbed. But as police began digging into what happened, that story changed. Court documents show Ramos-Jimenez told officers he was outside his home when he heard a loud bang coming from inside. He ran in, and that's when he says he found his 5-year-old daughter, identified by family as Layla, with a gunshot wound to her torso. Ramos-Jimenez says he and his girlfriend rushed Layla to a nearby psychiatric facility where they met up with an ambulance. She was then taken to the hospital, but Layla did not make it. Detectives arrested Ramos-Jimenez after discovering that the rifle used in the shooting was his. He allegedly told investigators he kept an AR-style rifle inside his 9-year-old son's bedroom, and according to court documents, he believes his son must have gotten a hold of it. Police say Ramos-Jimenez has prior felony convictions, including one from 2021 for trafficking narcotics. And under the law, that means he is not allowed to have a gun. But he reportedly told investigators he bought the weapon through a private sale for personal protection. In Arizona, private gun sales do not require a background check. According to the CDC, guns are now the leading cause of death for children in the United States. So far this year, there have been at least 79 unintentional shootings by children. 36 of them were fatal, according to Everytown for Gun Safety. The worst on record was 2023, with over 400 incidents. Back in court, prosecutors pushed for a $250,000 secure bond from Ramos-Jimenez, citing the seriousness of the charges, but the judge denied that request. Ramos-Jimenez was released without bail, and under the condition, he cannot initiate any contact with the witnesses or victims. And here to break down the story with me is criminal defense attorney and former prosecutor Kurt Altman. Kurt, thank you so much for coming on today.
Thanks so much for having me. Sorry, it's over this subject.
Right. This is just such a heartbreaking story. You know, a little girl is dead. Her brother is just 9 years old, and now the father is facing criminal charges. We know every case is different, but how does something like this usually play out?
Well, it's kind of hard to say. You're right. Every case is different, but clearly, the father in this case is going to be charged with being a felon in possession, or what we call in Arizona, misconduct involving weapons, at the very least. He admitted to having the gun, and he admitted to having a prior felony, which makes him a prohibited possessor. In other words, he's not allowed to have the gun. That's pretty significant. But what might come after that? Will there be charges relating to his daughter's death? It's very possible after a thorough investigation and the prosecutor's office takes a look at this.
This is a Law and Crime legal alert. If you received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. Morgan & Morgan is investigating claims that patients weren't properly warned about this risk. It's free to check, takes just a few minutes, and you don't pay unless they win. So scan the QR code on your screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. Right, and just his background alone, I know one thing that shocked a lot of people was the father was released without bail, even after prosecutors asked for $250,000. Why might a judge make a call in a case like this?
Well, I think at the initial appearance, all that they were holding him on at that point was being a felon in possession, meaning he had that weapon when he wasn't allowed. And so I think the judge, although knowing the circumstances of the case and the prosecutors probably really arguing that this is some sort of homicide, I think the judge looked at the law and the letter of the law saying, hey, this is a gun case. This is somebody that's not allowed to have a gun that did, and I can only set a bond or issue release conditions based on that, at least right now. And that's probably why he was released. And it's difficult to swallow sometimes, but I think that's probably what the law called for.
Police say that the AR style rifle was left in the 9 year old's bedroom. Is that automatically considered criminal negligence, or does it depend on other factors?
I think it would probably depend on other factors. I think that's a pretty good step towards criminal negligence or some sort of recklessness in this case. Certainly, it seems like the gun wasn't only left in the 9 year old's bedroom, but it had to be loaded unless a 9 year old knows how to load an AR-15. Had to be loaded. Safety apparently was off at some point because a round was discharged. So all those things are what the investigators and the prosecutors, I'm sure, will look at to determine if any other charges are warranted.
Right. The fact that not only was the gun allegedly in the child's room, but it wasn't locked away. We don't know, if the gun was loaded, anything like that. It just seems just really irresponsible. How does the law view that level of irresponsibility?
Well, I mean, obviously, tragically, a death ensued in this case. And so there can be charges arising from this incident anywhere from child abuse, just kind of child neglect and recklessness and taking care of your child, to homicide charges. Could be a negligent homicide, could rise to the level of a manslaughter in Arizona, or even second degree murder, which there's an intent in second degree murder in Arizona, which is reckless indifference to human life. And if the facts rise to the level that this was reckless indifference to human life, he may be charged with second degree murder.
Well, let's just talk more about intent. If the father didn't mean for this to happen, does that lessen the charges in any way? Because how would they be able to prove second degree murder?
Well, second degree murder, again, it's not that he intended anything to happen, but there is an intent requirement or opportunity to show intent called reckless indifference. And the way they would try to do that in this case is, hey, that they would prove that that gun, number one, was being stored in a 9 year old's bedroom. That's negligent, if not reckless. Clearly, that gun had live ammunition in it and one in the chamber that was able to be fired. Unless a 9 year old can load a weapon, who knows? If they can show that, that's another level of recklessness. If they can show that the safety was off and all they had to do was pull the trigger, that could be another level of recklessness. They can charge that through a grand jury, but then it'll be up to the jury, an actual trial jury, to determine whether they've met that burden. Did it rise to that extreme indifference to human life? And if it did, he could be found guilty.
Right. And like we said, the little boy that accidentally shot his sister was 9 years old. I would assume that because he's so young that he wouldn't face any charges. He is a child, but could the state decide to charge the child in any way, or is 9 just simply too young under the law?
Under the law, he would certainly, if they did decide something, go to juvenile court. But even at 9 years old, that's a little too young in the state of Arizona to be even charged with what they call a delinquent act. So it's very unlikely that there'll be any criminal type responsibility levied against a child, and nor should there be, from what I know. It doesn't sound like um, well, it's just horrible. It doesn't sound like the 9 year old should be charged with anything, but that's my opinion.
Right. And that little boy, I mean, I'm sure he's going to need a lot of therapy after witnessing something like that and being a part of just something so horrible. In cases like this, does the judge make a provision saying, "Hey, your child needs to go see a therapist," or not really?
Well, it's probably not the judge that'll be involved in the criminal case against his father, but certainly in a case like this, social services get involved from the beginning. Department of Arizona's Department of Youth Services will be involved. I'm sure there'll be an investigation as to other circumstances of how those children lived in that house, and it could end up being a dependency, what they call a dependency proceeding, and the child could be taken away, the child could be sent to foster homes. Certainly, those services are going to provide some sort of counseling and opportunities to help this child moving forward. So there'll be a lot of state involvement in the case.
And we know that the father has a felony record, including a conviction for drug trafficking. And legally, that means that he's not supposed to have any guns. So, how does that influence this case?
Well, I think that's the first step, right? That's an easy charge. I think that's what he was arrested for: misconduct involving weapons, being a felon in possession of a weapon. Pretty easy. He's a felon. He admitted he had a weapon, not allowed to have it. Um, how that factors into decisions on any other charges really depends on what the other evidence is, but it's certainly a start towards a reckless state of mind, an extreme reckless state of mind, because he admitted, based on my understanding, that he absolutely knew he was not allowed to have a firearm and had one anyway. That's step one. Everything else just makes it worse, frankly.
And police say that he bought the gun through a private sale. In Arizona, that is legal. But should the loophole in background checks be a part of this conversation?
Well, I think they already are a part of the conversation. Everything I've seen, people are talking about the loopholes about private sales of firearms. And if there weren't private sales of firearms, this gentleman wouldn't have had the firearm in the first place. I don't know if that's a fact or not, but it's a legislative decision. The legislature hears bills every year that reference, and they heard a couple this year, loopholes, so-called loopholes, and different gun bills. And it's really up to them, and it's up to the electorate to put the people in there that'll do that if that's what they want. Opinions vary. You know, you'll hear that, hey, this is freedom. People can be able to buy and sell whatever they want. And other people will say, hey, these are freedoms that we need to have restricted because it's so dangerous. Where you fall on that side, I don't know. But so far, the legislature has not cleared up those loopholes.
That's true. And just more on that, we know that Layla's death is unfortunately a part of a growing trend. Guns are now the leading cause of death for children in the United States. Do you think this case could shift how laws around gun storage are enforced?
I think it's certainly, laws and legislation gets made often, unfortunately, from tragedy. So certainly this is going to raise awareness. Certainly this is going to be subjects of discussion. Certainly this is going to compel somebody in the legislature to bring a bill next year to do just that, to fix the what we call the loophole. Um, what'll happen with that, I don't know, but certainly the awareness and the conversation will continue to rise as things like this continue to happen. There's no doubt.
And we talk about personal protection, but where's the line between protecting your family and putting them in danger?
I don't know that I can answer where that line is, but certainly there are things that this father could have done to protect his family from his weapon, whether he had it legally or not. We know it was illegal for him to have it at this point, but let's say it wasn't. That gun was not secured. That gun was in reach, obviously, of a 9-year-old. It was in the 9-year-old's bedroom. Um, Certainly, there's lots of things that can be done within the house, even if there is a firearm in the house, to protect children. And he just didn't do that in this case. And we see what the result is.
Do you think that this case will go to trial, or do you think that they could have a plea deal?
Wow, that's a good question because last I knew, the prosecutor's office haven't hasn't decided on the exact charges yet. If he's only charged, if they ultimately only charge him with being a felon in possession or misconduct involving weapons, I imagine that's something that'll resolve by plea. If they end up deciding that there's enough evidence to charge him with some sort of homicide, whether it's negligent, manslaughter, or even second degree murder, uh, that would raise the likelihood of a trial because it would very much be um, debatable on what his responsibility when it comes to that sort of crime is in this case. So it'll be interesting to watch.
Well, if it does go to trial, what do prosecutors need to prove? And could the suspect's charges evolve as the investigation continues?
Yeah, I think to answer your second question, I think the charges could evolve and increase. I think what the prosecutor's office, in conjunction with the police department investigating right now, is looking at is what can they prove. I'm certain that they probably want to charge some sort of homicide in this case. This is horrible. And if they can charge a homicide, they can. But I'm sure they're looking at the investigation to see what sort of things they can prove by his conduct. And by his conduct, I mean how he got the weapon, his knowledge that he wasn't allowed to have a weapon, how he stored the weapon, what he did with the weapon at home. We talked earlier that maybe the 9-year-old saw his dad play with the gun and that's why he knew how to grab it or pull the trigger. If evidence of that is developed, there's a very good chance that a homicide charge could come out of this.
Well, do you expect the defense to argue that this was just a tragic accident? If you were defending him, how would you go about this?
Let's say they charge him with some sort of homicide. I think if I'm defending the case, I go in there right away and say this was not a homicide. This is a family tragedy, the most horrific thing anybody could go through. Was he allowed to have that weapon? No. Is he guilty of being a felon in possession? Absolutely yes. Not disputing that. But he certainly never had the intent and never committed any conduct that would rise to the level of homicide of his 5-year-old daughter. He loved his daughter, family tragedy, and go on with that sort of defense. I think that's how I would do it.
Well, you just spoke about how the prosecution would bring up his past criminal history, most likely. How might the criminal history complicate his defense?
And it is what it is, to coin a terrible phrase that everybody uses right now. So I think as a defense lawyer or his defense, you admit that right away. Like, you don't try to hide that. You don't try to sugarcoat that. You're like, yes, he's got a felony conviction, but it's for drugs. It's for drug sales or whatever it was. Not a good thing, but certainly not a homicide. We're talking about two different things here, ladies and gentlemen, and you cannot find him guilty of some sort of homicide just because you don't like what he did in the past. I think they have to take it head on.
Do you think a jury might be more emotional in a case like this, especially with such a young victim and a young shooter involved?
Yeah, I mean, anytime children are involved, it's brutal. For a long time when I was a prosecutor, not a long time, but for a couple of years, I prosecuted child homicides when children were killed in some fashion, and they are the most emotional and draining cases for everyone in the courtroom, from the judge to the prosecutor to the defense lawyer, definitely to the jury. The difference with lawyers and judges is, unfortunately, we kind of deal in this world. We see a lot of this stuff. We see it every day. But a jury, 99% of the time, never seen anything like this, never heard anything like this, and they're sitting in a jury box hearing about the death of a child for the first time, and it's very emotionally draining. It's tough.
Could the 9-year-old boy take the stand? Is he considered a witness in this case? And how do courts usually approach interviewing or involving children in a situation like this one?
Well, he's certainly a potential witness. I have no doubt that uh, child law enforcement child interview specialists have already talked to him and gotten his story. They have techniques to use to talk to children and things like that. And I have no doubt that those are all on recording. Um, so does a prosecutor want to put an actual 9-year-old on the witness stand? Not if they can help it. So maybe those recordings can be used. Maybe they can make a case, no matter what it may turn out to be, without that 9-year-old. I think they would work real hard not to make that person a witness, but it's possible.
Do you think that they have a chance of winning their case without the 9-year-old's testimony? Or is there a fear that they could re traumatize the child?
Yeah, there is a fear that you could re-traumatize the child, and that's why you hope that you never have to put a 9-year-old on the witness stand. And do I think that they could win a case without the 9-year-old? It sounds like it. I mean, I don't know that much about the case, haven't seen the investigation yet, hasn't really been released, but it sounds like the father, uh, who will likely be the defendant, kind of admitted to everything. He said that he owned the gun. He said that he stored the gun there. He said that he was a felon and wasn't allowed to have the gun, and he knew that. So a lot of the evidence came from his own mouth, and they may not need the 9-year-old.
Right. Well, just such a sad and heartbreaking story all the way around. Kurt, thank you so much for coming on today.
Thank you, Kennedy. I appreciate it.
A fundraiser has been set up to help with funeral expenses for 5-year-old Layla. For Law and Crime, I'm Kennedi Walker.